Mr. O'Brien, $6 million from 3 deceased estates, cheques made payable to your wife, a forged charity CEO letter defaulted in this office.
Mark Lee O'Brien missed the one piece of evidence he could never explain away. He wrote it himself, and it was sitting in his own file.
I kept this firm alive for 20 years. I covered cases no one else in this city would touch. You go ask those families who was actually there when their estates needed handled.
$6,200,000. 3 Sydney charities. The last wishes of elderly clients who had spent their lives saving for the causes they believed in, rewritten in a solicitor's own handwriting and signed by no one. By the end of this footage, the man in the navy single-breasted suit would be charged under the New South Wales Crimes Act with fraudulently obtaining money from the clients who had trusted him to carry their final instructions into the world. He had drafted their wills himself. He had witnessed their signatures. And then, one estate at a time, he had erased the charities from the page. Quick question. When was the last time you actually read a will, top to bottom, that wasn't your own? Most of us never do. We trust the solicitor in the office, the firm with the brass plate by the front door, the partner whose signature is on the trust account check. Drop a comment if this case makes you want to check on a relative's estate file. And subscribe if you haven't. We cover these accountability stories every single week, and the next one is already loaded up on the right-hand side. The man being questioned in this footage is Mark Lee O'Brien, a 58-year-old solicitor, partner at a small but long-established practice on Sydney's northern beaches, member of the Law Society of New South Wales for more than 3 decades. He was born in 1962 in Chatswood, a quiet northern Sydney suburb that in the early 60s was still half orchards and half new subdivision. His father, Vincent O'Brien, was a clerk in the conveyancing department of a city law firm. Vincent spent his entire working life in the same sandstone building on Phillip Street and never made partner. His mother, Patricia, worked the morning shift at a small bakery on Victoria Avenue until Vincent's job allowed her to stop, somewhere in the late 1960s. By all accounts, the only thing Vincent O'Brien wanted for his only son was the practising certificate that Vincent himself had never been able to obtain. The story Mark would tell colleagues years later was that his father took him into the city one Saturday morning when he was 9 years old, walked him up Phillip Street, and pointed at the entrance to the Supreme Court of New South Wales. "If you work hard," Vincent told him, "you will walk through those doors one day as a solicitor. I will only ever walk through them as a clerk." Mark attended St. Aloysius's College on the lower North Shore, a Jesuit school known for producing barristers, doctors, and federal politicians. He was not the brightest boy in his year, but he was disciplined and methodical, and his teachers described him in school reports as industrious, courteous to a fault, and well-suited to a profession requiring patience and attention to detail. He played second-grade rugby with no particular distinction. He read every novel the English department assigned, and several more besides. He carried his father's old leather satchel, the one Vincent took to the law firm every day for 30 years, to school every day of year 12. He enrolled in a Bachelor of Laws at the University of Sydney in 1981, paying his way with a part-time job, stacking shelves overnight at a Coles supermarket in Crow's Nest. He completed his articles at a mid-sized commercial firm in the city, was admitted as a solicitor of the Supreme Court of New South Wales in March 1986, and accepted his first job as a junior associate at a small wills and estates practice in Mosman the same month. His father attended the admission ceremony at Phillip Street wearing a borrowed suit. Vincent O'Brien died of a heart attack 11 months later. Mark was 25. In 1989, he met Therese Caldwell at a charity dinner at the Mosman Returned Services League. She was a kindergarten teacher at a small private school in Cremorne, the daughter of a Warunga dentist, 3 years younger than him. They married in 1991 in a small ceremony at a sandstone chapel near Bogola Beach. Their first child, a daughter named Imogen, was born in 1993. Their son, Liam, followed in 1996. Mark spent the 1990s building a quiet, unremarkable career. He was not a high-profile lawyer. He never appeared on a television panel, never wrote for a law journal, never took a case to the Court of Appeal. What he did, year after year, was the unglamorous work of wills, probate, and deceased estate administration, drafting documents, witnessing signatures, sitting with elderly clients in their lounge rooms in Mosman, Cremorne, Avalon Beach, and Palm Beach, walking them, page by page, through the question of what would happen to everything they owned when they were gone. He was good at it. Not brilliant. Good. He listened. He remembered the names of clients' children and grandchildren. He attended their funerals. He was the kind of solicitor whose name was passed from one elderly couple to another at bridge clubs and church morning teas. Older clients said he reminded them of their own family solicitor from decades earlier. Formal, attentive, never in a hurry, never on his way somewhere else. In 2003, he was offered a partnership by another solicitor who had recently moved his practice from the city out to a small office building on the northern beaches. That solicitor's name was Patrick Maguire. Maguire was 9 years older than O'Brien, came from a similar middle-class Sydney background, and had built his own client base over 25 years of solo practice. He wanted a partner he could trust with the trust account, with the client files, and with the management of the firm when he was on leave. He chose Mark O'Brien, in his own later words to investigators, because Mark O'Brien was the most cautious lawyer he had ever met. The firm, known by the names of its two partners and a small brass plate by the front door, opened for business in March 2003. From the outside, it looked like the kind of suburban legal practice that exists in every Australian town. 3 small offices, a receptionist, a paralegal, a bookkeeper who came in 2 days a week, a waiting room with a leather couch and a side table stacked with old copies of the Australian Women's Weekly and the Reader's Digest. For the first 12 years of the partnership, Mark O'Brien did exactly what Patrick Maguire had hired him to do. He drafted wills, he administered estates, he attended funerals, he kept his trust account ledgers in order, he earned a comfortable, predictable income. He bought a 4-bedroom house in Linfield in 1998 and paid it off slowly across the next 2 decades. His daughter went to a private school on the North Shore. His son took up sailing at the Pittwater Yacht Club. By every external measure, he was exactly what his father had hoped he would become, a solicitor of the Supreme Court of New South Wales, with a stable practice, a stable family, and a stable life. And then, in early 2015, a man named Jeffrey Halloran died in a hospital bed at Royal North Shore. Jeffrey Halloran had been a client of O'Brien's for 19 years. He was a retired textile importer who had spent most of his working life living above his warehouse in Surrey Hills before retiring, in his late 60s, to a modest apartment in Avalon Beach. He had never married, had no children, and had outlived both of his siblings. His only living relative was a nephew named David Halloran, a primary school principal who lived in Newcastle and visited his uncle 2 or 3 times a year. Jeffrey Halloran's will, drafted and witnessed by Mark O'Brien in 1996 and updated 3 times over the following 2 decades, was unambiguous. After modest specific gifts to 2 old friends and a sum set aside for his nephew, the residue of his estate, more than $1.5 million in cash, listed shares and the sale proceeds of the Avalon apartment, was to be divided among 3 charities: a Sydney-based cancer research foundation, a homelessness service operating out of Woolloomooloo, and a small Catholic order of nuns running an aged care residence on the Central Coast, where Jeffrey's mother had spent the last 4 years of her life. He had spoken to O'Brien about those bequests every time he came in to update the document. He had explained in detail why each charity mattered. He had asked O'Brien more than once to make sure when the day came that the money got to where it was supposed to go. When Jeffrey Halloran died in February 2015, his nephew David retained O'Brien's firm to administer the estate. David Halloran had no experience with probate, no familiarity with the trust account system, and no reason to question the man his uncle had trusted with his final wishes for 19 years. To understand what happened next, you have to understand the architecture of a solicitor's trust account. In New South Wales, every law firm that holds client money is required to operate a statutory trust account governed by the Legal Profession Uniform Law and the Legal Profession Uniform General Rules. The account is held at an approved deposit-taking institution. It is audited annually by an external auditor appointed by the firm. Every deposit, every withdrawal, every check drawn against the account must be recorded against a specific client matter in a separate ledger. But here is the structural weakness. The same weakness Mark O'Brien had been looking at across the desk for 30 years, without ever, as far as anyone knew, considering what it could be used for. The audit is annual. The ledger entries are written by the solicitor administering the file. The checks are signed by a partner of the firm, and once a client is dead, that client cannot ring the office to ask about a transaction. A charity expecting a bequest is, by the standards of any other creditor, almost impossibly slow. The charity does not know when a benefactor has died. It does not know what amount has been left to it until the executor chooses to inform it. It has no automatic right to inspect the file. It will receive a check, perhaps months after the death, perhaps over a year later, and it will deposit that check without ever questioning whether the amount on it matches the bequest in the will. Because no one at the charity has ever seen the will, executors do not audit each transaction. They sign documents the solicitor places in front of them, and they trust that the figures on the page reflect the figures in the will. Solicitors administering deceased estates therefore have something almost no other professional has: controlled but discretionary access to very large sums of money belonging to people who can no longer ask where their money went. Payable to recipients who do not know they are supposed to receive anything, signed off by executors who are not in a position to check. It is a system that runs entirely on the assumption that the solicitor administering the file is honest. For the entire history of Mark O'Brien's career, he had been honest. And then, in March 2015, sitting in his small office on the northern beaches with David Halloran's signed retainer in front of him, and the file for Jeffrey Halloran's $1.5 million estate open on his desk, he stopped being honest. The first check was drawn on the 14th of May 2015. It was made out in the amount of $420,000. The payee line did not read the name of the Cancer Research Foundation Jeffrey Halloran had specified in his will. It did not read the name of the Homelessness Service. It did not read the name of the Catholic Order. The payee line, written in Mark O'Brien's own neat solicitor's hand, read Therese O'Brien, his wife. He recorded the transaction in the trust account ledger for the Halloran estate as proceeds of estate distribution. He created a new subledger under the name of his own wife and entered the $420,000 as a deposit on her behalf. The check was signed by him in his capacity as partner of the firm. There was no second signatory required for transactions within the standard limits the firm had set. Patrick Maguire did not see the check. The bookkeeper recorded the entry exactly as O'Brien wrote it. The annual auditor would not look at the trust account for another 8 months. Then he drew a second check, 2 weeks later, for $310,000. Then a third for $290,000. By the time the Halloran estate was fully distributed in December 2015, more than $1,200,000 of the money Jeffrey Halloran had left to his 3 charities had been transferred through the trust account into Therese O'Brien's name. But the checks alone were not enough. The trust account ledger, even with Therese O'Brien listed as the recipient, would not survive an external audit if there was no documentation explaining why estate funds had been paid to a person who was not named in the will. So Mark O'Brien, sitting at his desk on a Tuesday afternoon in late June 2015, did the thing that would eventually destroy him. He drafted a letter. He printed it on a sheet of plain A4 paper. He typed it on the firm's letterhead template after erasing the firm's name from the top. He wrote it in the voice of the chief executive officer of one of the 3 charities, the Cancer Research Foundation. He addressed it to himself, in his capacity as solicitor for the estate of Jeffrey Halloran, deceased. In the body of the letter, he had the CEO authorize the diversion of the charity's bequest to Therese O'Brien for the purposes of, in the wording he chose for the forgery, ongoing private trust administration, in accordance with our donor's prior instructions. The letter was signed with a scribbled signature he had drawn himself. He had never met the CEO. He did not know what the CEO's signature looked like. He filed the letter at the front of the Halloran estate file as the supporting document for the diversion of $1.2 million in bequests that had been written into the will of a man Mark O'Brien had known for 19 years. Then he did it again. In late 2017, an elderly client of the firm named Mrs. Beatrice Pellegrini died in a private hospital in St. Leonard's. Her will, drafted by O'Brien 6 years earlier, left more than $2 million to a children's hospital foundation and to the same homelessness service Jeffrey Halloran had named. By the time her estate was administered through the early months of 2018, more than $1.8 million of that bequest had been check drawn to Therese O'Brien and entered in the trust account ledger as proceeds of estate. A second forged authorization letter, this one purporting to come from the CEO of the Children's Hospital Foundation, was filed at the front of the Pellegrini file. A third client died in May 2018, a retired schoolteacher from Newport Beach who had spent 41 years teaching English at a local high school and had left more than $1.8 million to a homelessness service, a refugee resettlement charity, and the Catholic Aged Care Order on the Central Coast. A third check series, a third forged letter. The money did not sit idle. It went out as fast as it came in. In November 2017, Mark and Therese O'Brien purchased a $3.5 million property in Bondi, a renovated Victorian-era terrace 2 streets back from the beach, paid for in part with cash and in part with a mortgage that, according to bank records later subpoenaed by police, would never have been approved on the basis of the firm's distributable profits alone. They began paying additional contributions into their personal superannuation accounts at the maximum allowable rate. They paid for their daughter's university accommodation in cash. They paid for their son's first car in cash. They paid for a family holiday to Italy in cash. And, by Mark O'Brien's own later admission to investigators, a portion of the money, he was never able to specify how much, went back into the firm itself. The firm's trust account was, by mid-2018, running a deficit that he was concealing by drawing fresh estate funds to cover gaps created by earlier withdrawals. The structure was, in the language used by the prosecution at trial, classically Ponzi-shaped. Each new dead client was, in some part, paying for the gap left by the previous dead client. By the close of the 2018 financial year, more than $6,200,000 of money that had been left, in valid, witnessed, and executed wills, to charitable organizations across Sydney and beyond, had been redirected through the trust account of Mark O'Brien's firm into the Bondi House, the superannuation accounts, the gifts for his children, and the slow concealment of his own firm's growing trust account hole. 3 charities by the end of 2018 had received nothing. The question came across the partner's desk on the 2nd of October 2018. Patrick Maguire was 65 years old. He had been practicing law for 40 years. He had spent the last 15 years sharing an office with Mark O'Brien, and in all that time, he had never once had reason to question his partner's handling of a file. They had separate clients, separate ledgers, and a partnership agreement that gave each of them autonomous control over their own matters subject to the firm's joint signing protocols on the trust account. But on the morning of the 2nd of October, Maguire was reading the property section of the Sydney Morning Herald over his coffee in the firm's small kitchen when he saw a name he recognized. The article was a regular column listing recent high-end residential sales in the eastern suburbs. Under the heading Bondi, it listed a sale price, a street address, and the buyer's surname. The surname was O'Brien. The street was one Maguire knew his partner had been looking at properties on the year before. The price was $3.5 million. Maguire knew, almost to the dollar, what Mark O'Brien's profit share from the firm had been for the previous 5 financial years. He knew, because he had signed off on every annual partnership distribution himself. He knew that Mark O'Brien had a 4-bedroom house in Linfield with a mortgage on it, 2 children in private education, and a wife who had not worked outside the home since the early 2000s. And he knew that, on those numbers, his partner could not possibly have purchased a $3.5 million property in Bondi without either inheriting a substantial sum, which he had not, or borrowing against assets which Maguire knew did not exist. He walked into Mark O'Brien's office on the morning of the 3rd of October 2018, closed the door behind him, sat down in the client chair across the heavy mahogany desk, and asked the question directly. "Mark, how did you pay for the Bondi house?" The response Mark O'Brien gave that morning was the response of a man who had rehearsed this conversation in his head many times before. He told Maguire that the property had been purchased in his wife's name, not his. He told Maguire that Therese had received a substantial gift from a relative. He was deliberately vague about which relative. He told Maguire that his wife had taken independent legal and financial advice before the purchase. He told Maguire that he himself had nothing whatsoever to do with the transaction. Maguire did not respond in the meeting. He went back to his own office. That afternoon, he received a letter, hand-delivered from one office to the other across the corridor, from Mark O'Brien on the firm's letterhead, formally repeating in writing the position he had given verbally. The letter went one step further. It stated that Maguire, as O'Brien's business partner, had no entitlement to any information regarding Therese O'Brien's personal financial affairs, and was requested to refrain from further inquiries on the matter. Patrick Maguire read the letter twice. He folded it. He placed it in the top drawer of his desk, and then he picked up the telephone and called an external forensic accountant, a man he had known for 30 years who had no relationship with the firm, and asked him to conduct an immediate independent audit of the firm's trust account. The accountant began work the following week. It would take 11 days. The audit was conducted out of the firm's bookkeeping office on the evenings and weekends, with Patrick Maguire present and Mark O'Brien deliberately not informed. The accountant, a 58-year-old former forensic investigator with the New South Wales Crime Commission, began by reconciling the trust account bank statements line by line against the firm's master ledger. The discrepancies appeared almost immediately. 3 deceased estate files showed checks drawn against the trust account in amounts that did not correspond to any beneficiary named in the relevant will. The checks had been drawn in favor of one Therese O'Brien, a name the accountant did not recognize from any estate document. The ledger entries for those checks carried the description proceeds of estate, distribution, with no further explanation. The accountant pulled the underlying client files from the firm's archive. In each of the 3 files, Halloran, Pellegrini, and the schoolteacher from Newport Beach, he found, at the front of the file, a letter on the letterhead of a charitable organization, signed by an executive of that organization, authorizing the diversion of estate funds to Therese O'Brien for the purposes of, depending on the file, ongoing private trust administration, donor-directed disbursement, or alternative charitable distribution per donor's prior instructions. The accountant photocopied all 3 letters. He went home that night, and the next morning he made 3 telephone calls to the 3 charitable organizations. None of the 3 CEOs had written the letters. None of the 3 had signed the letters. None of the 3 had ever heard of Therese O'Brien. None of the 3 had received the bequests they had been promised in the wills of Jeffrey Halloran, Beatrice Pellegrini, or the schoolteacher from Newport Beach. The accountant reported his findings to Patrick Maguire on the evening of the 17th of October, 2018. The 2 men sat in Maguire's office for almost 3 hours. By the end of the meeting, Maguire had drafted a written report to the Law Society of New South Wales. The Law Society opened a formal investigation the following week. The matter was referred to the New South Wales Police Force Fraud and Cybercrime Squad in early 2019. O'Brien's practising certificate was suspended in February 2019. The investigators worked the file the way the auditor had worked the trust account, methodically, document by document, file by file. They obtained the underlying bank records for Therese O'Brien's personal accounts and for the joint accounts of Mark and Therese O'Brien. They traced the deposit pattern from the trust account checks into the accounts. They traced the outgoings from the accounts into the Bondi property settlement, into the superannuation contributions, into the daughter's university expenses, into the son's car, into the Italian holiday, into the small but consistent injections back into the firm's own trust account that had been used to paper over the deficit. They interviewed the 3 charity CEOs under formal caution. They obtained handwriting samples from Mark O'Brien and submitted the 3 forged authorization letters to a forensic document examiner. The examiner's report was unambiguous. The body text on all 3 letters had been typed on the same printer, using the same template, with the same line spacing and the same font. The scribbled signatures at the bottom of each letter were not the signatures of the named CEOs. They were, in the examiner's professional opinion, consistent with the natural handwriting of one Mark Lee O'Brien. And the files contained one more detail that, more than any other piece of evidence in the prosecution brief, would matter at sentencing. In the Halloran file, the original signed will, the document Jeffrey Halloran had signed in O'Brien's presence in 1996 and updated 3 times over the following 20 years, was still in the file. The pages were marked with O'Brien's own pencil annotations. Beside the residue clause leaving the bequest to the 3 charities, in O'Brien's own handwriting, was a small note he had written years earlier when discussing the bequest with his client. The note read, "Confirm with G, Cancer FDN, Homeless SVC, Sisters at CC." G, insistent. The man who would later forge a letter pretending the Cancer Foundation's CEO had agreed to redirect the money to his own wife, had, 2 decades earlier, written down in his own hand that the client was insistent the money go to the charities. By the time the police were ready to charge, they had every check, every ledger entry, every forged letter, every bank trace, and every word of the original will the solicitor had been hired to honor. Stories like this don't get the coverage they deserve. The victims here are charities, cancer research, a homeless service, an order of nuns running an aged care home on the Central Coast. None of them ever even knew they were supposed to receive a cent. If you appreciate watching cases like this finally land where they were meant to, hit subscribe and stay with us. We cover trust account theft, deceased estate fraud, and professional accountability every single week, and the verdict in this one is worth waiting for. The arrest was executed on the morning of the 15th of April, 2019. 2 detectives from the New South Wales Fraud and Cybercrime Squad attended the firm's office on the northern beaches at 8:50 in the morning. Mark O'Brien had already been at his desk for an hour. He was wearing the same kind of navy single-breasted suit he had worn to work for 30 years. White shirt, paisley tie, polished black brogues. The receptionist had not yet arrived for the day. Patrick Maguire was, by arrangement with the investigators, not present in the building. The detectives identified themselves at the front door, were buzzed through by O'Brien himself, and walked down the short corridor to his office. O'Brien stood up behind his mahogany desk as they entered. According to the body cam recording later tendered in evidence, his first words to the detectives were these: "I have been expecting you for some time." The senior detective placed a manila folder on O'Brien's desk. The folder contained color photocopies of the 3 forged authorization letters, side by side with sample handwriting from O'Brien's own client files. "Mr. O'Brien, can you explain how these letters came to be in your client files?" O'Brien looked at the photocopies. He did not pick them up. He did not sit down. He stood behind his desk in his navy suit, both hands resting flat on the leather blotter, and according to the detective's subsequent statements, his face changed color twice in the space of about 4 seconds. "I would like to speak to my solicitor." "Mr. O'Brien, you are entitled to do that." "Before you do, can you tell me whether your wife, Therese O'Brien, was aware of the source of the funds that were used to purchase the property at Bondi?" There was a long pause. According to the body cam audio, the only sound in the office for almost 11 seconds was the ticking of the antique clock on the bookshelf behind O'Brien's desk. "I would like to speak to my solicitor." The senior detective read O'Brien his rights. He asked O'Brien to step out from behind the desk. O'Brien did so. He was placed under arrest and walked out of the office that he had occupied for 16 years. He was not handcuffed at the office, on the senior detective's discretion. He carried his own leather briefcase to the unmarked police car parked outside. Just before he was placed into the back seat, he turned around once and looked back at the brass nameplate beside the front door of the firm. It was the last time he would ever see it. The charges were laid in the local court at Manly in late April 2019. The matter was committed for trial in the District Court of New South Wales in early 2020. The proceeding, by then known as RV Mark Lee O'Brien and RV Therese O'Brien, was contested. Mark O'Brien did not plead guilty. His defense at trial was, in part, that the firm's financial difficulties had created pressures that distorted his judgment, that the diversions to his wife were initially intended as short-term loans to be repaid from future profits, and that his wife Therese had not been aware of the source of the funds at the time of the Bondi purchase. The jury was not persuaded. After a trial that ran for 11 sitting days and included evidence from the external forensic accountant, the 3 charity CEOs, the forensic document examiner, the surviving executor of the Halloran estate, and the surviving family members of 2 of the 3 deceased clients, Mark Lee O'Brien was found guilty of multiple counts of fraudulently obtaining money from clients, contrary to the New South Wales Crimes Act. The sentencing hearing was held in March 2021 before a judge of the District Court of New South Wales sitting at Downing Centre in Sydney. The Crown tendered victim impact statements from each of the 3 charities. The CEO of the Cancer Research Foundation read his statement aloud from the witness box. He spoke about a piece of bowel cancer research equipment that the foundation had been forced to defer purchasing in 2017 because the bequest from Mr. Halloran had not arrived. He spoke about donors who had been told, indirectly, that bequests sometimes took time to settle. He spoke about the fact that the foundation had not known, until contacted by police in 2019, that anything had been wrong. David Halloran, the nephew, also read a statement. He said that his uncle Jeffrey had never been a wealthy man by Sydney standards, that Jeffrey had lived above his textile warehouse in Surrey Hills for 40 years to save the money he eventually left to his charities, and that the idea his uncle's final wishes had been intercepted by the very solicitor who had drafted his will was, in David Halloran's own words from the witness box, the worst thing he had ever had to imagine about another person. The sentencing judge, in remarks that ran to 43 minutes, addressed Mark O'Brien directly from the bench. This was not a single moment of weakness. This was a sustained, deliberate, and meticulously documented course of conduct, repeated across 3 deceased estates over a period of more than 3 years, made possible only by the trust the deceased had placed in you, and the trust the legal profession had placed in you in granting you the practising certificate that gave you access to their funds. You did not simply steal from charities. You wrote yourself into the wills of clients who had carefully written you out. The forged letter from the chief executive of the Cancer Foundation, a man you had never met, is, in this court's view, the single most disturbing document on the brief, because it represents not just an act of theft, but an act of impersonation. You silenced the very recipients your clients had chosen by pretending to speak in their voice. Mark Lee O'Brien was sentenced to 10 years imprisonment, with a non-parole period of 6 years. He was to be eligible for parole no earlier than 2027. His wife, Therese O'Brien, was sentenced separately to a 3-year intensive correction order to be served in the community under strict reporting conditions on the basis of her involvement in the receipt and use of the diverted funds. The Bondi house was forfeited as proceeds of crime and sold by the trustee in bankruptcy. The proceeds, together with the superannuation contributions that were able to be clawed back, were applied first to the costs of administration and then, in the part that survived, distributed to the 3 charities that had been named in the original wills. The Cancer Research Foundation received its bequest from the Halloran estate 12 years late. The Homelessness Service received a partial distribution covering roughly 40 cents in the dollar. The Catholic Order on the Central Coast received a smaller partial distribution, and, in a brief letter from the order's superior to the court, declined to participate in any further proceedings, saying only that the sisters would pray for the man who had taken what had been left to them. Mark O'Brien was removed from the role of legal practitioners of the Supreme Court of New South Wales in 2022. His practising certificate was cancelled permanently. He served his non-parole period at a medium-security correctional centre in regional New South Wales, where, according to court reporting, he worked in the prison library, reshelving books in much the same posture in which he had once stood behind a desk on the northern beaches, reshelving client files. The firm he had been a partner in for 16 years closed within 18 months of his arrest. Patrick Maguire took early retirement and never practiced again. The brass nameplate beside the front door of the office was unscrewed and discarded. Jeffrey Halloran's will, signed in 1996 and witnessed by Mark O'Brien with his own hand, is currently held in the archive of the District Court file as a tendered exhibit, the small pencil annotation beside the residue clause still legible after a quarter of a century. This case was the kind of betrayal that survives the courtroom. A solicitor who didn't just steal from the dead, but impersonated the people they had left their money to. But the case waiting for you on the right-hand side is somehow even more brazen. Click it now.